Okay.
Hi, everyone. I'm Mary Michael Smardelli. I'm a supervising attorney here at the Judicial Council of California. And I'd like to take the opportunity to thank the California Department of Social Services for inviting me here today to talk about Part 4 implementation, the court overview for the Family First Prevention Services Act, FFPSA. Next slide, please. So Part 4 of the Families First Prevention Services Act creates a new court oversight role. And in the federal act itself, it says that the court must hold a hearing within 60 days of the start of each STRTP placement, including changes to STRTP placements. And for each new placement or change, a court hearing is required to approve an assessment by a qualified individual. So if the qualified individual does the assessment and the court approves the placement, then that STRTP will be eligible for continued 4E funding. At each court hearing, the court has to determine the QI's report and whether the STRTP placement is the most effective and appropriate level of care, and whether the placement is consistent with the child's short-term and long-term behavioral health and permanency goals. For children placed in STRTP starting on October 1st, if they continue in those STRTPs at status review hearings, meaning post-permanencies, permanency or pre-permanency status review hearings, these hearings will require a supplemental report for the probation or social worker to include in to include information ongoing from the QI's assessment. And finally, in AB 153, which you've heard about earlier today, the Judicial Council was required to adopt rules and forms as of October 1st of 2021 to implement the 2 new code sections that implement FFPSA in California. Next slide, please. FFPSA further requires additional case plan documentation for children in STRTPs. For children in child welfare proceedings, 16501.1 is the code section that looks at the case plan requirements, and 706.6 applies to minors who are in foster care by the probation agency. Within 30 days of the child's placement into an STRTP, the case plan documentation must include information that demonstrates permanency planning that's inclusive of the child and family team, information reflecting the child and family team's efforts of collaboration with the qualified individual's determinations and assessment, and whether those align with the child and family team preference, and a description of home-based services to encourage the safety, stability, and appropriateness of the next placement, and plans and provisions for a family-based aftercare support. So all of these things are required to be in our case plan. Now, I know some of the counties don't regularly attach case plans to their court reports, and so this is something to consider as we move through the process. Now, as you're implementing FFPSA in your county, if you're not a county that regularly includes the case plan in your court reports, you may need to change that practice for the court report that specifically goes to the court for the STRTP proceedings under 366.21 or 727.12. Next slide, please. Okay, so I know there's a lot of anxiety about FFPSA and when it starts in California. And I know that in California, we've gotten off to a little bit of a late start since AB 153 wasn't signed until July 16th by the governor. And AB 153 is the law in California that implements FFPSA. But I want to sort of go through a timeline just to reassure people that that we're not going to be losing federal funding as of October 1st. So as of October 1st, FFPSA takes effect. It is not retroactive. So it only applies to children who are placed into STRTPs on or after October 1st of 2021. So as of the day of placement into an STRTP, $40 can be claimed. they can be claimed for up to 2 weeks. And then beginning the 3rd week of placement, the QRTP must have met the requirements to be licensed as a QRTP or STRTP, as we're calling it in California. And the timelines to start the QI assessment must start. So the QI assessment has to be done within 30 days of placement, of when the child's actually placed. And then the court hearing to approve or disapprove the placement must occur within 60 days of the placement. So even if a child is placed, for example, if a child is actually physically placed into an STRTP on October 1st, the court has until, let's say, December 1st of 2021 to actually approve or disapprove that placement. So I know it's still a really quick turnaround, but there is time for the QI to do their assessment or for that report to go to the court. And so I just don't want people to, get overly excited that we might be losing federal funding as of October 1st. It might take a while for this to get implemented, but as of October 1st, it's not like we are going to be stopping claiming $40 for these placements. Next slide, please. So in AB 153, the statute required the Judicial Council to create rules and forms. And I'm sure some of you are familiar with the Judicial Council's rules and forms process, but for those of you who are not, I just wanted to give a little history of why this is important and what it means for California. So rulemaking authority for the Judicial Council was actually given to us in the California Constitution. It gives the Judicial Council power to adopt rules for court administration, practice, and procedure to improve the administrative of justice, as long as those rules are not inconsistent with statute. Further, in Welfare and Institutions Code, Section 265, the Judicial Council is to establish rules governing practice and procedure in juvenile court proceedings, not inconsistent with the law. And finally, the rules of court have the same force of statute as long as it's not inconsistent with the statute, and that is from our case law. So the process for the rules and forms for FFPSA took a little bit of a different route than we usually go in the Judicial Council. And that's because we didn't have signed law until July, and we knew that every iteration of the trailer bill language that we saw included the Judicial Council creating something to take place October 1st of 2021. So the council, through the Family and Juvenile Law Advisory Committee, created a proposal of 1 rule and 5 new forms. And it did go out for public comment, but because some of the language is different in AB 153 than actually what circulated for public comment, there will be something that the Judicial Council considers on October 1st of 2021, so that there will be a rule and forms for court users to use to implement FFPSA. But we know that there might be changes that need to be made, so it will probably go out for public comment again in our winter cycle, which will be December to January about for public comment in 2021-22. Next slide, please. So AB 153. AB 153 created 2 new code sections to implement that new court process that we were talking about earlier. It requires that each placement of the non-minor or minor in a short-term residential program, including the initial and each subsequent placement into a short-term residential therapeutic program, shall be reviewed by the court within 45 days of the placement. So as you know, the federal statute says no more than 60 days. In California, they have elected to have a court hearing within 45 days, I think, to give a buffer in case we needed extra time to meet that 60-day window. This applies to all dependents, wards, and non-minor dependents. There's been some questions about what each subsequent placement means, and when that triggers a QI assessment, and when that triggers a court hearing. And it's my understanding that whenever there's a new foster care placement episode into an STRTP, that is what triggers the QI assessment, and that's what triggers the court hearing and the court oversight role. Next slide, please. So this is how the process is going to work. Within 5 calendar days, the agency must request a hearing to review the placement. And this is in our statute. So this means that we've talked about sort of earlier in the presentation that there's all of this work being done on the front end, like the interagency placement committee, the child and family teams, the qualified individuals assessment, all of that might be happening before the child's actually placed. But the way the statute and the way the federal law is written is that these timelines regarding court oversight and when the assessment needs to be considered starts when the child's actually placed or steps foot into the placement. So within 5 calendar days of the child actually being placed in the STRTP placement, the agency must request a hearing to review the placement. And this would be on the JV 235. This is going to be a mandatory form, meaning all agencies have to use it, child welfare and probation. And this is going to let the court know, hey, this child's been placed. Court, you need to set a hearing within 45 days. The agency, placing agency, whether that be child welfare or probation, must serve this request on all the parties. The statute doesn't define the parties. We have taken the opportunity to define the parties in the rule of court. And they include the parents, the child's parents, the attorneys of record, legal guardians, Indian tribes, or Indian custodians, if applicable, and then CASAs for CASAs for children in juvenile dependency, but not CASAs in juvenile justice proceedings. Also, with the request for hearing and the notification of placement under the JV 235, the agency must also serve a blank copy of the JV 236, and this is the input on placement in the short-term residential therapeutic program. And we'll go over this form a little bit later. Next slide, please. So the JV 235 is your request. It's the request that the agency uses. You provide your name and date of placement. And so the court knows exactly when the child was placed so that they can set the hearing within 45 days. And it also gives instructions to parents on how to make an objection to the placement. So if they don't agree, then they have the objection form or the input form to give their comment. Next slide, please. So request service requirements. I know this form is a little bit blurry, but don't worry, you have a copy of it in your materials. The placing agency must serve the request and the JV 236. The Family and Juvenile Law Advisory Committee wanted to ensure that parties were aware of their ability to object and provide input. So they required service of both documents. Sometimes we have this in other cases as well, where the service of an objection form is required or an input form is required at the time of service of a hearing. And that's the way the Family and Juvenile Law Advisory Committee wanted this process to happen. There's also then this service form, proof of service form, the JV 237. This is also a mandatory form. So there's other proof of service forms that we use in juvenile dependency and juvenile justice proceedings. This is one. This is a proof of service form that is specifically for these hearings and specifically for these children placed in STRTPs. And we're required under law, the Judicial Council, to create a process for the court to approve the placement without a court hearing. And so we'll get into that later, but this form is really important to make sure that the service form is submitted so the court knows that everyone was served with a copy of the report and the request for placement if they don't want to have a hearing. Next slide, please. Okay, so the setting of the court hearing. So within 5 court days, the court must set the hearing within 45 days of the start of placement and notice all parties of the hearing. So the court has to notice all parties, and we'll go over, there's an optional form for the court to use. Under the rule, it requires notice of the hearing, and you can approve without a hearing. The statute required the Judicial Council to come up with that process. So if the statute still requires a hearing to be set, but that hearing can be vacated if approved without a hearing pursuant to the process to be discussed. Meaning, the court can vacate the hearing that they're required to set if they approve the placement before the hearing date. Next slide, please. Okay, here's the notice form, the JV 238. So this is the form that I was talking about was optional. So once the court says, I'm going to set a hearing within 45 days, they have to notice the parties that the hearing was set. The court can do that either through this form, it's an optional form, they don't have to use it, or they can do that through other ways that they've already established to notify parties of proceedings. Next slide, please. All right, so now the child's placed. The agency's notified the court that the child's placed. The court has set a hearing within 45 days. What happens now? So if it already hasn't started, the QI assessment has to start. And the QI assessment has to be incorporated into a report for the court to consider at that hearing in 45 days. The contents of this report are outlined in statute under 361.22C as well as 727.12C. The assessment, the QI assessment includes a copy of the assessment, determination, and documentation. This is broad and could include a lot of confidential and privileged information from a youth's file or communications that the QI had with the youth or family. The statute does not clarify whether confidential information should be excluded. However, the Family and Juvenile Law Advisory Committee felt that we needed to address that in the rule of court. So in our rule of court, we have said that the report shall not contain any information that's privileged or confidential pursuant to current state or federal law or regulation without the appropriate waiver or consent. Meaning the child or the non-minor should know what information is going to the court, what information is being used in assessment, and know that that information may end up in a court report for other parties to see. And so they will have to sign a waiver in order to, for that information to be used in a court report. What's also required for the hearing report is the case plan documentation that we talked about earlier. So again, thinking about those courts who don't, or those counties who don't attach their case plan to their court reports, it's actually required for the hearing report. There has to be information in the report that the tribe was conferred and placement preferences under 361.31 in the case of an Indian child, and that active efforts were made to prevent the placement in an STRTP. So that's important. And then a statement of whether any party objects to the placement. So the QI will probably, after they've talked to the Interagency Placement Committee, after they've talked to the CFT, after they've met with everybody, will probably know whether or not there's an objection to the placement. And if they do, they have to include that information in their hearing report, regardless of whether anyone's going to file their own objection or their own input form. If there's a disagreement, then that needs to be documented by the QI or the agency in the hearing report. Next slide, please. All right, the report for the hearing. So now we have this report for the court hearing. The QI assessment has to be held within 30 days of the placement. So that report must be served on the parties no later than 7 calendar days before the hearing, okay? This is different if we're gonna have, we're gonna ask for an approval without a placement. But if we're gonna have a court hearing, then that report must be served on the parties 7 days prior to the court hearing. It must be filed with the court as well 7 days prior to the court hearing. Okay, so it has to be served on the parties no later than 7 days prior to the court hearing, and at that time it must also be filed with the court. Next slide, please. All right, so now here's the JV 236, our input form, our parties objection form. So again, must be served on the parties, and it's what a party must use to make a formal objection to the placement and preserve a right to a hearing. So if there's not an objection, the court may approve the placement without a hearing. So it's really important that if people want to object to the placement, that they have the opportunity to do so and they complete the proper form. The other issue that happened that we'll talk about is that there's local rules and practices can determine the process for notice and filing of these forms. So many courts have their own rules about how you file these forms, who can file these forms, and so those local practices will still apply. Only parties can formally object. So parties that we were talking about regarding the child, the parent, the legal guardian, the tribe, but anyone can have input into the minor. Anyone who has an interest can provide input to the court. So anyone who has further information that might be helpful to the court can provide an input form, but only parties can formally object to the STRTP placement. Next slide, please. This is just a copy of the JV 236 for you to look at. Item 5 is the objection required to prevent approval without a hearing. So you have to check that box if you want the court to have a hearing on your objection. The space provided for the party to inform the court and their reasons is in 6. And you can also, again, provide input without objecting. So people can actually just file this form if they have more information or different information that they want to give the court. Again, this is a mandatory form, so it must be served, and it's required to be used to make any formal objection. Next slide, please. All right, so now we're getting to the approval without a hearing. So we talked about the timelines for the approval we talked about the hearing timelines, which is the 5 days, the 45 days, and the 7 days prior to the court hearing for service and receipt of the report. The approval without a hearing was established under subdivision H of AB 153 that requires the Judicial Council to develop this process. So in our proposed rule 5.618 subdivision F, it gives the requirements for the process to obtain approval without a hearing. The objection process is central to this timeline, right? So knowing when and how long someone has to review the report and object has to be taken into consideration in order to determine if you're going to be having a hearing or not. And even if someone doesn't object, even if no one objects, the court can still hold a hearing if they want to. They don't have to approve the placement without a hearing. It's just an option for them if it makes things easier for everyone involved. Next slide, please. So the approval without a hearing, 4 requirements must be met. So remember how we talked about the report needs to be served 7 days prior to the court hearing if there's going to be a hearing. Well, if you don't want a hearing, if you're asking the court not to have a hearing on this case, the report must be filed at least 10 days before the scheduled hearing. So you moved up the timeline a little bit because it wouldn't be people would always have a hearing unless you were able to get the information sooner. The placing agency has verified through the JV 237 that we talked about, the proof of service, that they served the report at least 10 days prior to the court hearing on all parties. So the agency says on that form, they file it with the court, they said, we've given everybody the report. No party has objected to the placement within 5 court days of receiving the report. So that's a little bit harder, right? We know when the report is served, but the statute doesn't actually tell us which method of service is required. So, it could be first-class mail, it could be personal service, it could be electronic service. So, if it's mail, we don't quite know when the report's received. But anyway, the statute says within 5 days of receiving the report, or the rule does, and that the court intends to approve the placement based on the information before it. So those are the 4 requirements that must be met. The court will have 5 days to determine whether to approve the placement without a hearing. And if the court does approve the placement without a hearing, then the court must vacate the hearing and notify all parties that the hearing has been vacated. And so this really would take place when there isn't another hearing scheduled, right? There's nothing to say that if there's another hearing scheduled within that 45 days of a child being placed, that this hearing can't be set that same day as the other hearing. But if it's a standalone hearing, there's a process for the court to approve it without a hearing. This will probably start happening as things start moving more quickly in FFPSA right now. As things start and we start implementation, we're probably going to have more court hearings because it's probably going to take some time to get processes and procedures in place to ensure that timelines are met. But as we move forward, there's probably going to be more cases that'll probably be approved without a hearing, as long as the information is appropriate and no one's objecting to the court. Next slide, please. All right. So the other thing that the Judicial Council decided to do through their Family and Juvenile Law Advisory Committees is proposed to do, again, the meeting's on October 1st of 2021. So hopefully we will have rules and forms implemented on that date. But it allows the court to develop a local rule under procedures in Rule 10.613 to approve placements without a hearing. Meaning, we've created a way in our rule for the courts to approve without a hearing. But local courts have different ways that they communicate, different ways that they work. And so if a local court wants to make their own local rule of how this procedure and process will work to approve the placement without a hearing, they can create a local rule to do that only applies in their county. It has to follow the procedures in the Rule of Court 10.613, which means there's a process to get local rules verified through the Judicial Council, and that process still has to be followed. But it does give the local courts an option to create their own rules. At a minimum, the local rule, if a county decides to create one of their own rules to approve the STRTP placement without a hearing, at a minimum, that local rule is required to meet the same requirements that a party can object through the JV 236, that there's service at least 10 court days before the statute, and that the approval is consistent with the requirements of rule and statute. So because the timelines are so tight, counties may want to do different things. Some counties may be able to get the reports done faster, so they can move up that 10-day time frame if they want to. But anyway, there still has to be a right to object. There still has to be some time between the service of the report and when a party can object in order for the court to consider whether or not to approve the placement without a hearing. The local rules are going to take a while for counties who want to do them. So you do have an option under the current rule, proposed rule, to approve the placement without a hearing. And you can follow that process while local counties are deciding how they're going to move forward and whether they're going to establish a local rule of court. Next slide, please. All right. So when we're at this hearing or approval without a hearing, there are statutory requirements. The court has to do something, right? They have to make findings and they have to approve a placement. So they have to consider evidence in order to approve or disapprove that placement and make 3 findings or determinations. They have to find or determine whether the needs of the minor or non-minor dependent can be met through the placement in a family-based setting, or if not, whether a placement in a short-term residential treatment program, therapeutic program, provides the most effective and appropriate care setting for the minor or non-minor dependent in the least restrictive environment, right? So everything in the report, the assessment that the QI is doing, has to provide the information for the court to make these determinations. A shortage or lack of resource family homes shall not be an acceptable reason for determining that needs of the non-minor or minor dependent cannot be met in a family-based setting. And I know that this particular finding that the court has to make is very, people are saying it doesn't take into account that we don't have a lot of family-based settings. But I mean, the point is that if the child doesn't need that level of care, then we need to find something in the community or a family member or some way to support that child's needs, not in a congregate care or a STRTP setting. The second determination or finding the court has to make is whether a short-term residential treatment therapeutic program, level of care is consistent with the short and long-term mental and behavioral health goals and permanency plan of the non-minor dependent. So this is in the dependency statute under 1.22e. The delinquency statute is a little bit different. It takes out that level of care determination. So as you see in 361.22, the dependency statute, it says determine whether a short-term residential therapeutic program level of care is consistent. In the delinquency statute under 727.12, it says determine whether the short-term residential therapeutic program itself is consistent with the short-term and long-term mental and behavioral health goals and permanency plan for the minor and non-minor dependent. So there are some differences between the child welfare and the juvenile justice statute under 361.22 and 727.12. This is just one of them. So careful review and oversight of the two statutes is needed. I will tell you in the rules, in the forms, we are not separating them out right now. So it'll be one form that's being used for both the review hearings under 361.22 and 727.12. The third thing that the court must determine or consider is that in the case of an Indian child, they must determine whether there's good cause to depart from the placement preferences set forth in section 361.31. So as you know, there are specific placement preferences for Indian children and for our Native American community. And so there does have to be justification and good cause to depart from those placement preferences and place a child into an STRTP. After considering all of this evidence and considering all of these findings, then the court must approve or disapprove the placement. That approval or disapproval must be made in writing or on the record. So the court has to say what its factual findings, and they must document it either in writing or somehow on the record. And we're going to be talking about documentation in 1 minute. Next slide, please. So some clarifications that the rule makes that are not necessarily in statute. So in making the determinations and making the findings that the court has to make to approve or disapprove the placement, the rule says that the court can consider all relevant evidence to the determinations. Meaning it has the QI assessment in front of him, but it can use other relevant evidence in order to make its determination of whether to approve or disapprove the placement, or whether to make look at relevant evidence, additional relevant evidence about whether the short-term or long-term goals are going to be met in the short-term therapeutic program, STRTP. The rule also clarifies that these determinations or findings that the courts are making are to be made by the preponderance of the evidence. So that's the standard of proof for these proceedings, is the preponderance of evidence. The court also must approve or disapprove the placement based on the determinations it's made and whether it appears that the child or non-minor dependent's best interest will be promoted by the placement. So not only is the court looking at all of the determinations and evidence in front of it, but ultimately it's also what's in the best interest of the child. And finally, the rule makes it very clear that there's no continuance beyond 60 days of the start of placement. This is noted in 361.22a. It's not noted in 727. It's another variation or difference between the two statutes. But the reason why this is so important and the reason why this is in statute is that if the court doesn't approve the placement within 60 days, then that placement is no longer eligible for the 4E reimbursement dollars. So it's really important for everybody to understand that this 60-day time frame is a hard time frame in order to continue to pull down 4E dollars for that placement. Next slide, please. All right, the findings and orders. So we were just talking about how important that 60 days is for 4E funding. So the findings and orders form to make sure that the court is making the appropriate findings and the appropriate orders for this hearing in order to continue to pull down those 4E dollars. It's a mandatory form. It's the JV 239. It's the order that the court must use in order to approve or disapprove the placement, and it provides all the required findings and orders. So because there's such an importance to this particular hearing, and there's such a need to make the proper findings and orders, the Family and Juvenile Law Advisory Committee decided that this form should be mandatory, that all courts, when they are determining this type of hearing under 361.22 or 727.12, need to use this particular form. So for all the courts and counties out there, this is the form that you will be using to document all of your findings and orders. Next slide, please. Okay, so what happens if the placement is not approved? So if the court says, nope, I'm not approving this placement, I've considered all the evidence and I don't think this is the appropriate placement for this particular child, then the court orders probation or child welfare to transition the minor or non-minor to a placement setting that's consistent with the determinations made pursuant to subdivision E within 30 days of the disapproval. Meaning you have 30 days after the court says no to find another placement that will appropriately meet the child's needs and will not be in that STRTP setting. Next slide, please. If the placement's approved, then there's certain evidence that the court must consider, additional new evidence under FFPSA that the court has to consider every 6 months to determine whether the child's continued placement in an STRTP is necessary and appropriate. Next slide, please. So here are the ongoing status report review requirements for those children who are in STRTPs, whether they be minors or non-minors. So number one, there has to be an ongoing assessment of the strengths and needs of the child that continue to support a determination that the child cannot be with family or in another family-based setting, such as a foster home or placed with a resource family. And that the placement in the STRTP continues to provide the most effective and appropriate care in the least restrictive setting. So, and that the setting is consistent with the short and long-term mental health and behavioral goals and permanent placement for the child. So that's one thing, right? There's going to have to be additional evidence in the report for the court to make this to find that this placement is necessary and appropriate based on this ongoing assessment. There also has to be a documentation of the child's specific treatment or service needs that will be met in the placement and the length of time the child is expected to need the treatment or placement. So what's going on in that specific STRTP that will meet the needs of the child, and how long is a child expected to stay there, right? These are supposed to be short-term placements. And so we need to know how long the child is meant to stay and what the transition plan out looks like, right? And then for a Medi-Cal beneficiary, the determination of services and expected length of time of service suspended by Medi-Cal shall be based on the medical necessity requirements. And then third, there has to be this documentation in the report for the court to consider of intensive and ongoing efforts made by child welfare or probation that are consistent with the child's permanent plan to prepare the child to go home, be placed with a fit and willing relative, a legal guardian, or an adoptive parent in a resource family or tribal approved home or in another family-based setting. So this is really where a lot of the efforts that social workers and probation officers are going to need to be documenting. What are these intensive and ongoing efforts that they're making to get this youth out of this STRTP placement? What are they doing to look for family? What are they doing to work with the family to identify the appropriate services that the child needs in order to come home or to be placed in a different setting? So those three things, the ongoing assessment, the documentation of the specific treatment or services, and the intensive and ongoing efforts are three new determinations that the court will have to make in order to decide whether the child's placement, ongoing placement in an STRTP is necessary and appropriate. And these determinations and this new evidence will be required every 6 months that the child is placed in an STRTP and will be required at every status review hearing. Next slide, please. So just for a little bit of a reminder, this is our last slide. There is a chance for changes. So all of the things that we've talked about today about the process and procedure that has been laid out, that's implementing the statute, those will circulate again for public comment. We know we probably didn't get it right the first time. And we know, as in every federal statute that we implement in California, there's often cleanup legislation and often things that we discover during the first part of the implementation process that need to be clarified. So these rules and forms that I talked about will be circulated again for public comment in our what we call our winter cycle, our next cycle. And that public comment period is between December and January. And we have right here the website so that you can check out to make sure that you see what the proposals are and what the changes are. And of course, we'll make sure to circulate that widely so people have an opportunity to comment, so we can make the best forms and rules for everyone to follow so that we can implement FFPSA properly in California. And with that, that's all I have. So thanks, everyone, and I hope you have a great day.